Thank you for joining us.
1 second.
Hello, everyone. Thank you for joining us today. I am Luiza Manuelian with the law firm of Landegger Verano, which is an employment law firm exclusively representing employers and business owners. I'm here with my colleague, Evelyn Zarraga, and we're joined by our guests from Coastal Payroll, Christian Evans and Nicole Wilson. Today's presentation is a two-step process. First, we're going to give you the knowledge of California law as it relates to wage and hour based on our experience in defending class and PAGA suits over the years. And then we'll introduce you to Coastal Payroll. We'll discuss the tools that's necessary to make sure you have the proper way of implementing these policies into your company. We will do a very quick overview of class action and PAGA lawsuits and dive right into the common issues of employers faced with wage and hour lawsuits. Please note that nothing in this presentation shall be construed as legal advice, but rather a general presentation of the overview of wage and hour topics. Now, you'll notice that all of you are muted. We will have a chat box where you can put in your questions at the very end. Hopefully we'll have time to address some of your questions, but we will not be answering questions in the middle of presentation. With that said, let's jump right into class action. So the first single most expensive thing for an employer to face is a wage and hour class action lawsuit. A class action is a type of representative suit that resolves the claims of a large group of similarly situated individuals. Small employers are not immune from class action suits. Evelyn and I have had anywhere from 10 to 12 employees, clients with such small number of employees in class action lawsuits. To get a class certified, the judge must have some discretion to look at the arguments for and against class certification. If the class is not certified, the case typically proceeds on an individual basis. Alternatively, if it does become certified, the case moves to pretrial procedures. So either way, if it's an individual case as opposed to a class action case, compliance is really important. And this is the scary part for all of you business owners. There is no insurance coverage for class action settlement or verdict. Under California law, not paying your employees proper wages is considered a crime called wage theft. Thus, there is no insurance coverage for wage theft. Employer is personally liable for any settlement verdict related to wage and hour class action lawsuits. I'm going to pass this down to my colleague Evelyn, who's going to talk about PAGA.
Thank you so much, Luiza. I'm really excited to be presenting today and very happy that we're able to put this presentation together to help employers get into compliance and sort of figure out what tools they need to do that. So diving right in, I'm going to start talking about PAGA. So PAGA stands for Private Attorneys General Act. And what it is it allows an employee to sue their employer on behalf of the state of California to seek civil penalties that the state could otherwise collect. And like a class action, it is a representative action. And what that means is that a single employee can sue on behalf of dozens, hundreds, even thousands of their coworkers. Unlike a class action, however, it's not subject to the same strict certification requirements that a class action is. And significantly, when you resolve a PAGA claim, it doesn't automatically resolve the underlying individual claims. And what this means is, let's say that you settle a PAGA action. The individuals that were included can still file their own individual claims for those unpaid wages, unpaid meal premiums, and even related statutory penalties, say for wage statements or waiting time penalties. And so as a result, these actions can be very costly. Just defending a PAGA action can be costly, and at the end of the day, you may still be subject to additional claims. And from our experience in handling class and PAGA actions, what we often see is that attorneys will leverage these PAGA suits in order to get bigger settlements. Because at the end of the day, these the payment from these settlements goes, the majority of the payments for these settlements goes to the attorneys and the state of California, with the employees getting very little. So in 2024, there was a PAGA reform, and there was a lot of hope that this reform was going to help employers. Unfortunately, that is not really what happened. And so for that discussion, I'm going to pass it on to Luiza to explain to us what actually happened with the PAGA reform.
Exactly like Evelyn said, it was a little bit of a trick, if I have to admit. I think we were all hoping on that, we as in everyone on the defense side, were hoping that the reform would really provide some sort of a relief for employers. And arguably there's some benefits, but I'll dive right in. So last year around July 1st, Governor Newsom signed into law what we call as the PAGA reform. Although the reform has some benefits for employers, such as the standing requirements and expanded cure provisions, the overall effect has not been particularly helpful for employers. The reform was enacted to reduce the number of PAGA filings, but has had quite the opposite effect. In fact, prior to 2024, there were 25 PAGA letters filed with the LWDA. And since the reform, the filing has increased anywhere from 25 to 75 per day. So you can imagine that's how many employers in California are receiving the PAGA letters. Despite the reform, PAGA is here to stay, and it remains a major litigation risk factor for California businesses. With that introduction to class and PAGA, Evelyn will jump right into the reason why we're here today, which is to identify the common allegations of class and PAGA lawsuits and what we see in defending these cases.
Thank you so much, Luiza. So I will just dive right in. So I would say the number one claim that we see in class and PAGA actions is meal and rest break violation claims. And what that is when an employer fails to provide a compliant meal break or compliant rest break as required by California law, in a class action, the employee can try to collect the premiums that were due when this violation occurred if they were not paid. I would say the second largest claim that we see is wage violations. Now, this includes unpaid minimum wages or unpaid overtime wages, usually stemming from off-the-clock work, rounding practice, or regular rate of pay issues. Now, the reason that these two are the number one claims that we see in class and PAGA actions is because they appear on the face of the records. So what that means is, if you look at the time records, if you look at the pay records, do you see meal break violations? Were premiums paid? Was it documented why the meal break was late? Why the meal break was short? Why overtime wasn't paid? All of this stuff appears on the face of the records and therefore provides an easier avenue for plaintiffs' attorneys to certify a claim or to establish liability with respect to a PAGA case. The third claim that we typically see in a class and PAGA action is reimbursement. So reimbursement, I would say probably the number one claim is like cell phone use. So if you're requiring your employees to use their cell phones on a daily basis for work purposes, if you're communicating with your employees on a daily basis with your work purposes, or for any, not necessarily on a daily basis, you need to be aware that you may have to reimburse their employees for that cell phone use. And finally, the last thing that we typically see alleged in these class and PAGA claims is what we refer to as derivative penalties. So let's say that your employee was due meal premiums or rest break premiums that they weren't paid, or overtime was not calculated and paid correctly. The wage statement can be deemed inaccurate because it did not accurately reflect all of the meal premiums that were due or all of the overtime that was due. And so that's why it's referred to as a derivative penalty. So like Luiza said, the main thing with all of these cases is really to be in compliance and sort of be aware of, where these pitfalls are and protect yourself. And so with that said, I'm going to let Luiza jump into the number one claim, which is meal and rest break violations.
Thank you, Evelyn. So I think most employers and HR personnel knows about rest breaks and lunch breaks in general, but really this is going to kind of focus precisely what issues Evelyn and I often see. First, with regards to meal breaks and waivers, right? In California, An employer may not employ employee for a work period of more than 5 hours per day without providing the employee with a meal period of not less than 30 minutes. So what that means is if you have an employee that works 5 hours, they're entitled to a meal break. And that has to be 30 minutes. It has to be within the 5th hour of when they start their shift. And it has to be uninterrupted. It can't be 29 minutes. It can't be 28 minutes. It has to be minimum of 30 minutes. And we'll dive into a little bit more as to what we recommend as, designating 30 minutes later on, but that's the basic general law. If your employees are working less than 6 hours, you can waive it, right? If their shift is not going to be more than 6 hours, you can have a meal waiver. The meal waiver has to be in writing. It has to be signed by the employee and the employer. And I'm going to give an example in this case. We had a case together, Evelyn and I, where the employer provided a meal waiver. It had 2 options for the employee to check box. Yes, I waive my meal. No, I don't waive my meal. And the employee checkmarked both boxes, which clearly means that the employee didn't quite understand what they're waiving, and they didn't fully, it was not considered a proper waiver. Second meal break and waiver is when an employee works more than 10 hours a day, they're entitled to a second meal break. And again, it has to be minimum of 30 minutes and it has to be uninterrupted. A second meal break can be waived. Once again, it has to be in writing and it has to be signed by the employee and the employer. And a lot of times employers confuse. They say, oh, we have a meal waiver. Well, one meal waiver cannot replace the other meal waiver, because if they have a 6-hour work, that's specifically for employees who work 6 hours or less. The second meal break waiver has to do with if an employee works for more than 10 hours and has 2 lunch breaks, they can waive the second, but not the first. Rest breaks. Rest breaks are 10-minute rest breaks of 4 hours or a major fraction thereof. Sometimes Evelyn and I have had cases where they say, well, my employees only work 4 hours. So, but it's called or major fraction thereof. That means if they work 3.5 hours, they're entitled to 10-minute of rest breaks. Again, it has to be uninterrupted. Rest breaks do not need to be documented. And, Evelyn and I both agree that we're not necessarily fans of documenting rest breaks, because if you do document it, you have to make sure every single rest break is properly documented. And we've had many cases where our clients documented some but not others. And it really works against you, because it's harder to argue that they've taken the rest breaks when they've only documented some and not others. And probably one of the most common mistakes we see is we have really kind employers as our clients, and they offer their employees the opportunity to combine rest and meal break. We definitely do not recommend doing that. On few occasions, for special occasions, perhaps here and there with the consent, but as a general rule, I do not recommend combining those two. And they should work 2 hours, take their 10-minute rest break, work another 2 hours, take their lunch break, and then the second rest break thereafter. It needs to be separated out. Again, meal breaks need to be documented, but not rest breaks. With that said, I think I'm going to pass it on to Evelyn to talk about the meal and rest break best practices. In other words, what to do as a general practice for your company.
Thank you, Luiza. So just to start off, I'm going to start off with the common meal and rest break issues that we typically see in these cases. So in our experience, I would say that a lot of employers are aware that if the meal break is missing, they have to pay that meal break premium. But in analyzing records, in connection with our class and PAGA cases, we do our analysis in-house. And in doing so, we've sort of picked up on what the main issues typically tend to be. And I would say timing problems and duration problems are the biggest problems. So timing problems. What that means is the meal break is taken late. So the employee has completed 5 hours of work before commencing their 30-minute meal period. And so a lot of employers will be paying meal premiums when the meal break is missing, but not when it's late. And we also see a lot of situations where the employees are working over 10 hours. They don't have that waiver, and they're not being provided that second meal break. It's like employers know that they have to provide that first one, but it's not really on their radar that the employee is required to take a second meal break. So that's just something to be aware of. And the same thing with duration issues. Are you meeting that 30-minute mark? Are the meal breaks being rounded? You do not want to round meal breaks. And we also don't recommend auto-deducted meal periods. Now, in very rare situations, an employer is actually technically legally able to auto-deduct a meal break, such as when, let's say in a factory, there's a bell system and all operations cease during the meal period. But, it still sort of sets up the employer on a sort of defensive track, because then you have to prove that you had a procedure to sort of account for the exceptions. So even in situations where you have a bell system, it's always our recommendation to also have the employees clock in and clock out for lunch in order to have that documentation showing that the employee did take the compliant meal break, and also to have the documentation to be aware of when you do need to pay the meal premium. And finally, the third common issue that I see is more of a policy issue. We very often encounter employers who have a handbook or a rest break policy that is requiring the employee to remain on the premises during their meal or rest breaks. So, I want to say that there are some exceptions where you can require employees to remain on the premises, but that's going to be the exception, and there's, very that's very sort of nuanced exception. So in general, most employers aren't going to be able to do that, and so the employees have to be able to leave the premises. They have to be free of the control of the employer. They have to be completely off duty with respect to meal and rest break premiums. And then finally, the last thing I want to comment here is in a lot of cases that we've defended, we see employers are paying meal premiums but not rest break premiums. And this happens because there really is no procedure. The employer has no procedure in place to document when a non-compliant rest break occurred. Now, like Luiza said, we generally do not recommend recording rest breaks, but we do suggest that you have a procedure so the employee can report and say, hey, I did not get my rest break today. I missed one of my rest breaks because work prevented me. And so that the employer has that procedure to know when to pay the rest break premium. So Louise, if you could, yeah, thank you. So best practices. So just to sort of go through each of these, clear policies. One, you want to make sure you have clear policies, like that example that Luiza presented with the 2 check boxes. You need someone to check and make sure that you didn't get the 2 checks in that situation. You want to make sure that your policies are in compliance. And so typically we recommend that employers review their policies at least once a year. And that includes with respect to meal waivers. A lot of times employers will implement a meal waiver when the employee gets hired, but they may miss someone. So you want to check, do all of your employees that are taking they're working 6-hour shifts, do they have this voluntary meal waiver? The second thing we want to mention is documentation. With all of these issues, documentation is key. You want to have the ability to document whether the miss, late, short meal break was because the employee chose to do that. So let me give you an example of when it's voluntary. Let's say your employee needs to pick up their daughter from school, and so they need to, take a later meal break in order to be able to do that. In that situation, the employee is voluntarily taking a late meal break because they're choosing to do so. And so you want to have that documentation. And again, with documentation, with rest breaks, like we said, rest breaks do not need to be documented, but you do need to have a procedure for documenting when a non-compliant rest break occurred. And accurate timekeeping is also key. You want to have a system in place to flag when meal break violations occurred. So, a lot of times, we have employers that have digital timekeeping system, and that's great. But how are you reviewing these timekeeping records to identify when meal break violations occurred? Does your system automatically flag them for you? Is there like a note, where the employee can leave a note in order to say, yes, it was late because I chose to, or no, it was late because of, work reasons. So you want to be able to have this sort of accurate timekeeping in place. And the last thing I would mention in terms of best practices is to have proper scheduling. So we talked a lot about meal waivers. With a 6-hour meal waiver, we find that in a lot of instances, employers will schedule an employee for exactly 6 hours. And invariably, sometimes the employee is going to show up a little earlier or leave a little later, and it's going to go over that 6-hour mark. And when that happens, that meal waiver is no longer effective, and now you owe a meal premiums. And a meal premium is 1 hour of pay at the employee's regular rate of pay. So you really want to be avoiding having to pay, all these extra premiums. So we recommend that if your employees are going to be using these meal waivers, that you schedule them for, 5 hours and 45 minutes, 5 hours and 30 minutes, in order to not accidentally, trigger a meal break violation when they go over. The same thing with scheduling meal periods. If you schedule your meal periods exactly 5 hours into the employee shift, a lot of times they're going to show up a minute early, and all of a sudden, you have a late meal break because it was a minute or two late. With that being said, I'm sure Luiza has plenty of examples that she can provide us where these practices weren't implemented correctly.
Yeah, and I think it's important to note that from defending all these cases, I think a lot of our clients, they come from a really good place. I think most employers really want to do a good job. They want to provide the meal premiums when necessary. And a lot of times it's the lack of fully understanding these laws and requirements and documenting everything and having a good record. So one of the issues I had not too long ago was I had a client who had a mental health institute. So they scheduled their case managers to work to see patients, right, every 30 minutes precisely. And then within the 5th hour of when that session ended, they were supposed to take their lunch break. And the same thing after lunch. So there was really, if you look at the schedule, there was no opportunity for them to take the 10-minute uninterrupted rest break. So I told them you have to go and break it down, and you have to give them time. Also, do not have them take their lunch break within the 5th hour, just like Evelyn said, because what happens when a patient is late? So all of their appointments get delayed, so they get a late lunch and they don't take their rest break. So you've got 2 meal premiums already because it wasn't scheduled properly. So if you can proactively schedule your your employee schedule so they are able to take their rest breaks, their lunch breaks within the allotted time, you can avoid all these potential penalties. With that said, I'm going to introduce you to Nicole and Christian from Coastal Payroll. Just to let you guys know, we've actually seen their presentation. We've seen how they document these things, including what Evelyn mentioned as to the reasons why they're taking a late lunch break, etc. And we were quite impressed with their systems. So that's why we're having them join us today. And with that said, Christian, take it away.
Thank you so much. Hi, everyone. I'm Christian Evans, an HCM sales consultant with Coastal Payroll. Thank you, Luiza and Evelyn, for having us today. We're really excited to be here. Coastal was founded 18 years ago in San Diego, and we're proud to be the largest independent payroll provider on the West Coast. We focus on payroll and HR support, and we do it by combining intuitive technology with personalized service from a team that truly takes the time to understand your business. If you're running a business in California, compliance is no small task. Labor laws are constantly evolving, and even small payroll mistakes can lead to major consequences. We're seeing more class action lawsuits and PAGA claims than ever, as Luiza mentioned earlier, and many of them stem from errors that can be prevented. That's why having the right payroll provider, especially one with robust timekeeping and strong HR support, isn't just nice to have, it's essential. These aren't just back office tools, they're the first line of defense in protecting your business. With that, I'd love to pass it over to Nicole Wilson, our lead training specialist, to walk you through some of the tools we've built in our system, especially when it comes to compliance safeguards. Thank you.
Thanks, Christian. Hi, everyone. As Christian mentioned, my name is Nicole Wilson. I'm a lead training specialist over here at Coastal. Can we advance the slide? At Coastal Payroll, we're intimately aware, as Christian mentioned, of those wage and hour regulations laid out by the state of California and discussed by Evelyn and Luiza in this presentation. Our technology platform can help you stay in compliance and do a lot more in addition to that. Firstly, Luiza and Evelyn highlighted that clear policies, documentation, accurate timekeeping, and proper scheduling can help you avoid those very costly mistakes and comply with those laws that are in place. For instance, if we note here on the slide, the top left, meal penalty alerts can be clearly presented on employee time cards, as well as for client administrators in our system. Employees are able to add notes, crucially, to their time cards to document those meals from the examples of Luiza and Evelyn that were possibly taken after the 5-hour threshold voluntarily. Meal penalties can also be reviewed and excused in the client administrator view in the event, again, that note is entered by the employee and the employee's late lunch was voluntary. Next slide. Documentation clearly is quite important. And so we have various auditing tools in our technology platform that are very, very easy to navigate. For example, we see at the top here of this slide, a way to audit meal penalty alerts to filter based on different dates or pay periods, based on labor as well, and then quickly correct those issues in the system on the time card in real time. In addition, meal waivers that were mentioned by Luiza can easily be stored in our system, and employees can be grouped in the platform so that maybe you have specific time card policies that are isolated to certain individuals, like those that work a night shift and get a shift premium. This documentation, all of it, will live in an employee's electronic personnel file and can easily be referenced at any time. Last slide. Finally, with regard to attestation and verification features in Coastal's platform, we can configure these to document employee responses regarding those meal and rest breaks. We see an example here where in time card verification, they are confirming with an electronic signature that their hours, their meal breaks, their rest breaks, and unauthorized overtime, or the avoidance of that, they are signing that with their verification. In addition, we see the example of attestations triggered upon punch. So an employee can punch in and then will be met with an attestation or punch out in this instance that indicates that they were taken, right? And whether or not that breast break was taken voluntarily or the rest break was not taken involuntarily, so forced to work, so that those things are documented in the system. We also have the ability with time card verifications, I should note, for employees to object and provide notes. All of these, again, are fully reportable in the system for you to audit and reference. Most crucially, Coastal has the ability to alert an employee of the time threshold by when they need to take a meal based on their clock-in time. This can address someone incurring a meal penalty by taking a meal only a few minutes later than was necessary, as Evelyn and Luiza mentioned with their examples. We can configure as well these alerts based on your preference. So for instance, we can set that threshold at 4 hours and 30 minutes instead of the 5 hours to really truly avoid those overages that are just really by a couple minutes or so. Finally, with regard to proper scheduling, Coastal has various tools that can help you organize meal and rest breaks to avoid those penalties, maintain your compliance with the state, and make sure, again, that you have coverage for your organization, but avoid all of those costly mistakes that can come along with this. Thank you.
Yeah, we're gonna
Thank you
pass
so
it
much.
to There we
Nicole, for
go.
that. Sorry, I was on mute. Thank you so much, Nicole, for that. I really appreciate how like everything is all in one place. You know, this is what we were talking about in terms of having that documentation, being able to review it, you know, sort of taking proactive steps with the alerts. And so I really appreciate that you were able to present all that. So diving right back into the most common claims that we see, overtime payrolls. The one thing that I want to highlight with overtime pay is the importance of an employer having a workday and a work week definition. This is because the overtime pay calculations are all based on how the employer has defined their workday and their work week. For example, under the FLSA, which is the federal rules, employers are required to pay overtime when an employee works over 40 hours in a work week. So this is the general rule. So if you've defined your work week from Monday to Sunday, then you're going to be looking at that discrete Monday to Sunday on a weekly basis to determine whether the employee has worked over 40 hours in a work week. Now, under California, there are more stricter rules in that it also provides for daily overtime. So again, you know, going back to this definition of a workday, in California, if your employee works over 8 hours in a workday, this will trigger overtime at 1.5 times the regular rate. So suppose that your employee starts their shift at 8 o'clock at night. And you've defined your work day as midnight to midnight, and they finish their shift at 6 p.m. They've worked 10 hours, but 6 of those hours have fallen into work day number 2, and so overtime is not actually due. Now suppose that they work a second shift on day number 2, and that shift is 6 hours. Now, because the earlier shift, 6 hours of that shift fell into day number 2, combined with the second shift, now they've worked 12 hours in day number 2. So in this scenario, the employee would actually be due 4 hours of overtime. But what we often see is that employers are paying overtime based on the shift and not on the workday. So in this case, if the employer had paid overtime for the first shift, which was 10 hours, they would have only paid 2 hours of overtime there. And then the second shift was 6 hours, they would pay no overtime. So they would have only paid 2 hours of overtime instead of 4. Now, that being said, in some cases, let's say an employer has a 24-hour operation, they may be required to have a second workday definition or in order to account for that those employees working that night shift, because an employer should have workday definitions that do not result in an underpayment of overtime to their employees. So in this scenario where the employee is regularly working this overnight shift, when they get to that last shift in that work week, part of that shift is going to fall into the next day, and they may not work additional hours that day, in which case they may be losing overtime. So, you know, you really need to have a company, a payroll company or timekeeping system that can account for these multiple workday definitions. And then just sort of moving on with double time, any hours worked over 12 hours in a workday is double time. And then finally, the last component is the second consecutive day overtime and double time. So the first 8 hours on the 7th consecutive day in a work week is considered overtime. And again, this is where the work week definition is very important and is key to determining whether that 7th day is triggered. So let's say an employer has a work week definition that's Sunday to Saturday. The employee works Monday to Saturday and then the following Sunday. That following Sunday is actually going to fall into the next work week. So even though in this example, the employee has worked 7 consecutive days, they haven't worked 7 consecutive days in the same work week. So it's very important to have a work week definition and a work day definition. And then with that second consecutive day rule, if they do happen to work a 7th consecutive day in the same work week, all hours over 8 on that 7th day are considered double time. Now, Luiza, we can jump to the next slide. So common overtime issues that we see, and I'm just going to go through these. Off the clock. So off the clock is when an employee is performing pre or post shift activities, sometimes meetings. But essentially what happens is the employee is performing work but is not on the clock, and therefore those minutes are not being captured. Now, we saw this a lot during the COVID era with health screenings. A lot of employers were having their employees show up to work and do a health screening before they were able to clock in. And so as a result, it was sometimes 1 minute, 2 minutes off the clock that were not being compensated. And so we saw a lot of claims with respect to the COVID era regarding the sort of off the clock work. The second issue that we see with unpaid wages and overtime issues is rounding practices. So California courts have really cracked down on rounding. Generally, we do not recommend rounding, especially with technology today. Employers are able to track employee work hours to the minute, and they should be paying employers to the minute. And let me give you an example of why this could be a problem. We had a client who had operations of a factory, and so they turned on the machines at a very specific time. They turned off the machines at a very specific time. So as a result, the employees were showing up a few minutes early to be there before the machine started, and would leave a few minutes later to make sure that they would leave after the machines were shut down. So once we did our analysis, we found that over 80% of shifts, this sort of rounding actually was in favor of the employer, not the employee. The hours were effectively rounded down. So the employees were working 8 hours and, let's say, 5 minutes, and that was being rounded down to 8 hours. And so now not only were they losing minimum wages, but they were also losing overtime pay. And then finally, the last thing I want to emphasize with overtime is unauthorized overtime. A lot of employers will have in their policies and their handbooks that employees are prohibited from working unauthorized overtime. And this is fine, except the issue that we often see in a lot of cases is the employers then don't pay their employees when they happen to work unauthorized overtime. So what employers should be doing is disciplining their employees. If your employee is working unauthorized overtime, you want to write them up, you want to document, you want to discipline, and even eventually, if they continue to do it, you may terminate them. What you don't want to do is not pay the overtime. You don't want to go in and edit the time card and say, this wasn't, authorized. We're going to edit your time card and not pay for it. And finally, the last major issue that we see with overtime claims is regular rate. But I'm going to pass this on to Luiza to cover the regular rate issues.
So I'm going to jump right into regular rate, but before I do, Evelyn, as you're describing the unauthorized work overtime, you and I have had cases, some very recently, where there was an issue of whether or not the employees were authorized to work. And we've had a client that had to go in and edit their time. And I want to really emphasize that I do not recommend as an employer or a manager to go in and edit your employees' hours that they've submitted. Because you felt that they were working there without your authority. If you know the employee's working, you still have to pay them. And like Evelyn said, you can discipline them, but don't go in there and just edit the time and say, no, you weren't authorized to work overtime, so we're just not going to pay you. So we're going to just dock your time. So do not do that. Okay, so we talked about meal breaks, rest breaks. We talked about overtime. And what do all of these things have in common? Regular rate of pay. Understanding what is a regular rate versus base rate really is critical, because we see this almost in every single class of PAGA cases we've had, right? To know what the distinction between the two, and when an employer has to calculate the regular rate versus the base rate when they're analyzing overtime, meal breaks, sick pay, etc. So I'm going to dive right into regular rate, what is considered to be included, and then we'll talk about later as to what's not included in your regular rate of pay. So regular rate includes your base hourly rate. So if you have employees making $20 an hour, that is their base rate. Shift differentials. We've had clients that have employees who work night shifts. They get an extra $1 an hour. Right? That's called a shift differential. So they can work from, let's say, 8 a.m. to 2 p.m. with the $20 an hour, and then they get from night shift from 10 p.m. to 6 a.m., they get $21 an hour. So that's the shift differential. Non-discretionary bonuses. So bonuses that's non-discretionary means the bonuses are provided without necessarily anything the employee is doing. For example, the restaurant tips. Some restaurants have a policy that they automatically provide an 18% gratuity. If it's automatically provided, that means that goes into their regular rate of pay. But if it's a tip that's based on the discretion of the customer, then it's no longer considered part of their regular rate. Incentive pay has to do with production bonuses and attendance bonuses, piece rate earnings, and commissions. Commissions can be very tricky because some employers pay their employees with commissions plus hourly, some just pay on commissions. So all of these things are part of the consideration for regular rate of pay. Why it matters? Because if you don't get the regular rate correct, everything to do with overtime pay, meal and rest break premiums, sick pay, reporting time pay, all of these things will not be calculated correctly. So we've had cases where our clients calculated the regular rate of pay for overtime purposes correctly when they had a shift differential, but then they didn't calculate the meal premium correctly, and they didn't calculate the sick pay correctly because they didn't take into consideration the shift differential. So regular rate is computed on a per work week basis, and calculations differ for flat sum versus production bonuses. And Evelyn will talk about flat sum bonuses in a bit, but that's what's considered part of the regular rate. What's not included in the regular rate is discretionary payments, gifts, holiday bonuses not tied to the production hours. Reimbursement for business expenses is not part of it. Premium pay, so whatever you pay for a missed breaks, reporting time, split shift, that's not part of the regular rate. And discretionary tips, the restaurant that I just mentioned to you, if it is at the discretion of the customer to give a tip or not, that's not considered part of their regular rate of pay. Common calculation errors, employers frequently miscalculate by excluding required elements or by including items that should be excluded, leading to either underpayment or overpayment of wages. Actually, Evelyn and I, we did a case recently, and the client, the employer, actually overpaid because some of the employees, let's say for a few hours, they went into the knock shift, which is a higher rate. So they calculated incorrectly, paying all the other employees an incorrect rate for the higher rate for a meal premium. So again, this is really, if you understand the difference of when to use regular versus base, it really helps you not only to be in compliance, but it could also ultimately save you money if you understand, the correct rate of pay. Incorrect regular rate calculations can lead to significant liability in class and PAGA suits, with penalties accumulating for each affected pay period and employee. So what does that mean? So if you have a class action that goes back 4 years, right? PAGA goes 1 year, class goes 4 years. So imagine if you don't have the correct regular rate of pay. So all of your employees, let's say you have 1,000 employees, so you have miscalculated for all of those employees, which means their wage statements are correct. Their rate of pay is their overtime is incorrect, meal premium, sick pay, all of these things are all incorrect. So the penalties start to pile up. So it's really critical to understand the correct regular rate of pay to calculate. And then we're going to go into 2 shift rates. So this is a little bit trickier, right? So if you have employees that work 2 different rates, because if they're working the night shift or day shift, and then you have to figure out like what is the correct rate of pay to pay. So the error that we see is that they use the base rate instead of the weighted average rate when employees receive 2 rates or shift differentials for purposes of paying overtime pay, sick pay, and other premiums. The correct approach is when an employee works at 2 or more different hourly rates in a work week. And remember, Evelyn talked about the definition of work week. This is why it's really important to have that, right? The regular rate of pay is the weighted average of all rates determined by dividing total earnings for the work week by total hours worked, including regular earnings during overtime hours. This is a very common mistake that we see a lot of in the medical industry and any businesses that operates 24 hours a day with different shift rates or differentials. It is tricky, and we see a lot of times they don't calculate it correctly. And what Evelyn and I often see is they'll calculate overtime correctly, but they won't calculate the meal premiums correctly or the sick pay correctly. So again, it's important to understand and to designate correctly what rate of pay you're paying your employees. I think we're gonna have Evelyn give us some other examples of cases with improper rate of pay.
So I just want to make sure that we have enough time, so I'm going to hone in on two particular issues on this slide. The first being flat sum bonus errors. Luiza was talking about various bonuses having to be included in the regular rate of pay computation. So under California law, there's this sort of distinction between a production bonus versus a flat sum bonus. Something like like an attendance bonus would be considered a flat sum bonus, essentially because it's not tied to making your employee work more hours or be more productive or put more effort. So with an attendance bonus, all they have to do is show up. It's not going to be tied to their overtime hours, for instance. And so as a result, when you're computing the regular rate, the divisor in this situation is only the regular hours, the straight time hours, and not all hours worked. And I don't want to get too much into the math here, but only to say that, the employer needs to be aware of what kind of bonus it is. Is it a flat sum bonus? Is it a production bonus? Is it discretionary? Is it non-discretionary? Because these distinctions are going to be really important in calculating that regular rate. And then second, the pay period complications. So a lot of our clients have semi-monthly pay periods, and we're emphasizing this sort of importance of the work week. And so what ends up happening is you have a work week that may fall into two pay periods. If your pay period is from the 1st to the 15th, it's not going to exactly overlap, two discrete work weeks. And so when that happens, you just need to sort of be aware that you need to look at the hours for the whole work week, not just the hours that fell into this pay period for that split work week. And with that being said, I'm going to pass it on to Nicole, who's going to show us some of the tools that they have for simplifying these calculations for you.
Thanks, Evelyn. Yep, Coastal can definitely help you when it comes to blended overtime configurations and definitions of work week and work day. So as Evelyn emphasized, the need to establish and clearly define that work day or work week aids you in calculating overtime, double time, and meal and rest breaks properly and making sure that things are taken timely. Our platform is unique in that you can not only define both work day and work week in the system, but you can apply these once again to various types of employees in the system. So perhaps those working various shifts at your organization, they may have differing work days or work weeks. This will lend to calculations of 7-day consecutive overtime and double time for specific employees as opposed to others. The system will automatically apply these workday and work week definitions for you so that you can focus more on other important parts of your business and don't have to drill down and separate yourself. With regard to blended overtime and the regular rate of pay calculations, Coastal is very well versed in creating custom earning codes. So down at the bottom of this slide, you can see we have created custom earning codes for a client based on the types of non-discretionary bonuses and flat sum bonuses that they offer to their employees. So we can really drill down and make sure that the calculations are correct, ensuring that you don't either underpay or overpay those employees when you calculate those regular rates of pay. Next slide, please. Okay. All types of regular rate of pay calculations are possible at Coastal. This obviates you from manually calculating these very often complex rates, combining lots of different pieces, as was mentioned by Luiza and Evelyn. And as Luiza mentioned, the regular rate of pay will need to include those things like shift differentials, non-discretionary bonuses, commissions. What's key here is pay stub transparency for us. So at Coastal, we make sure that pay stubs are easy to read and transparent for both client administrators and employees. Here we can see, so on the top two examples, we can see that both meal penalties and sick pay are calculated at the regular rate of pay instead of that hourly rate. These calculations in the far left example are broken down by a work week definition for a client who would be a semi-monthly payroll frequency. These are broken down so that the meal and sick regular rates would be different based on that work week. Evelyn and Luiza have spoken here, right, to the importance of this aspect when we're talking about wage and hour compliance related to blended overtime. Evelyn also discussed that unique situation of blended overtime in California. When a flat sum bonus is paid, this is a particular circumstance that requires the OT and DT premiums to be paid on the bonus separately and then with a different computation. Once again, Coastal can automate all of these calculations for you. We can combine various types of bonuses, even combine the different types, so flat sum plus production based, when you're paying those to an employee in the same pay period. I have had quite a bit of experience configuring blended overtime at Coastal. And in my experience, many of our clients have had quite a headache when they're trying to calculate these amounts on their own. Coastal's here to do this for you and to work with your organization to keep you in compliance, avoid those costly mistakes, and do the math. We can do it. We can do your math. Thank you.
Thank you, Nicole. So I think we have about 8-9 minutes. I'm going to quickly cover these other compliance items and see if we have time for some Q&A. I just want to focus on the payday rules specifically because it's really important for employers to define their work week, workday, and pay period and designate the paydays in advance. So for pay periods, other than the 1st to the 15th and 16th to the last of the month, must be paid within 7 calendar days, okay? Otherwise, it has to be within 10 days. So sometimes we have clients that do different dates. Sometimes they do it from midweek so it's really important to have it in your handbook to clearly define when is your payday and what, if you're doing semi-monthly, bi-weekly, and what are the dates that you're, the payroll date as well as when the payment is actually processed. Sick pay, as you probably all know, we have 40 hours of paid sick leave at a regular rate of pay in California. But as we all know, Los Angeles has 48 hours. Some, in Santa Monica, I think if you have 72 hours, if you have 25 or more employees. So it really depends. So you have to know where the employees are actually working at and what the requirements are for sick pay. And then the final paychecks must be paid immediately upon termination if you're terminating the employee, or within 72 hours if employee quits without notice, or at separation if employee gives 72 plus hours of notice. With that said, I don't know, Evelyn, is there anything else that you want to add to it? Because we have the last slide has some additional stuff.
It looks like we do actually have a question in the chat.
Okay.
The question is, if commissions are paid each pay period, does the regular rate of pay get calculated for each pay period? Now I can answer that, Luiza, if you'd like.
Sure.
So when it comes to the regular rate, it's actually based on the work week. So to the extent that you're able to sort of determine whether, let's say you have a bi-weekly pay period, which is often easiest when it comes to regular rate of pay computations and pay stubs and all that. If you can determine whether or not the commission was earned in week 1 versus week 2, you should really allocate it that way. But let's say you really can't, that it was, the work was performed during the entire pay period and it sort of led to this commission, then what I would suggest is to sort of have an agreement with your employee that because you're not able to sort of specify which work week or, exactly it was earned, then you're going to be doing the calculation based on a pay period. But just sort of to answer the question generally, if you can allocate it based on work week 1 versus work week 2, then you should technically do it based on a work week. We have some other questions coming in. If your business in LA County, do you have to give 48 hours of sick time annually?
Well, the city, it's city focused, so you have to figure out what city. Every city generally has its own rules. So whenever clients ask us about paid sick leave, we have to find out what city if you're in. So it depends which part of LA County. But if you're in a city of LA, it's 48 hours.
There's
Sorry.
another sick pay related question. Is the 48-hour sick leave for Los Angeles based on where they work or where they live?
It's where they work, right? So if they work 2 hours or more in that city, then that's the rate you apply. So that's the general rule. So sometimes we've had clients that work in multiple cities because they have different locations. So the rule of thumb is if they work 2 hours in the higher rate, let's say they work in city of Los Angeles and then they go to Gardena, right? And if they work at least 2 hours in the city of Los Angeles, then you apply the 48-hour rule.
What if employees take more than 10 minutes during their 10-minute breaks?
You discipline them. You reprimand them. You say it's 10 minutes. Like, I always say, like, sometimes there's exceptions, right? It depends on the circumstances, but in general, it's 10-minute, and that's the rule. We've had clients that they do 15-minute. It depends what your policy is. And again, employee handbook is really important for this reason. One is you want to document and you want to inform your employees what the policy is on rest breaks, meal breaks, etc. And that you want to also indicate that, hey, if you don't follow company policy, which you signed the acknowledgement of at the end of the employee handbook policy, that you may be disciplined for lack of compliance. And this could be one of the issues. I've had personally many cases where the employees provide a lot more than 10-minute rest breaks. And it's really up to the employer if that's your choice, but if your policy is 10 minutes and they're not in compliance, they take more, then you can discipline them.
So I think I don't know if you want to do just sort of a quick summary of some of the things that we talked about today and closing remarks.
Yeah, I would say one is handbook, have a good policy in place with regards to everything we talked about, meal break, rest breaks, inform your employees and have them acknowledge of these policies, right? If you're going to document your rest breaks, again, I do not recommend it. Evelyn doesn't recommend it, but if you are, it has to be precise and accurate. And for meal breaks, you definitely have to have a clear record of when they clocked out. Sometimes we've had cases, and when we ask our clients for their, as soon as we get hit with a class and PAGA lawsuit, the first thing we ask our clients is a copy of their time and pay records. And a lot of times we see there's no punch out for lunch. So there's no punch out and punching back in. They just put the total hours, which is a problem. It's a massive problem because we don't know when they took their break. And assuming that we have ways of showing that they took a rest break, right? I mean, a lunch break, we don't know when they took it. So we have a 5th-hour rule violation. We have a potential 30-minute violation if it's less than 30 minutes. So it's really important that you have a good timekeeping system of keeping when they took their breaks, their lunch breaks, and when they got back to make sure it's not less than 30 minutes. And I think we're getting more questions, but I'm kind of getting things
sort of running out of time. Yeah. I will say there was a question here about if you require, I kind of read it quickly, but if you're requiring your employees to say use their cell phone in order to log in or log out, for the timekeeping system, you do need to reimburse for cell phone use. I'm not sure if that was your question there.
Yeah, we actually have a case with that issue right now where, the client is basically making the employees get an app on their cell phone to clock in and clock out, and there's no other way for them to clock in and clock out. Then you do have to reimburse for a portion of that cell phone because it's required for the job. Can an employer decrease the pay rate of an employee? I'm not sure how to answer that question because
Sort of depends. It's kind of
Yeah, it really depends because
It really
you know
depends.
there is also something called an adverse employment action. So, and this is
Yeah.
not really related to
This
wage
is not
and
really,
hour issue. Yeah, this has to do with more like discrimination, retaliation. So, I think the answer is it depends. I would have to know more about the circumstances. Yeah.
but we really are running out of time, so I don't know if you want to jump to the last slide.
Right. Okay. Thank you, guys. Thank you so much. Let me quickly jump to the next slide. There we go. Thank you for being here. I know this definitely doesn't cover everything, and we try to keep it as short and succinct as possible. If you have any questions for us, please feel free to reach out to me and Evelyn. If you have any questions regarding payroll and timekeeping, please feel free to reach out to Christian with Coastal and Nicole with Coastal. And thank you for being here. I don't know if Christian, you want to add?
No, I think you said all this is amazing. You know, we're here to support you. Obviously, there's probably a lot of questions. I mean, this is a hot topic, and I'm you know, coming from these different perspectives. We're here to add value. And if you ever have any questions outside of this, please don't hesitate to reach out.
Yeah, and we will be, this is recorded and we'll provide the recording and the slides. A lot of times people will ask about that. So if you guys want the slides, it will be sent out, including the recording. So with that said, that's all, folks. Hope you all have a good day.
Have a good
Thank you all.
Take care.
Thanks for coming.
Bye. Thank
Bye.
you.